Hello, everyone, and welcome to a new session with Rights and Responsibilities Awareness Initiative. Today, we are super lucky to have Nick Preston, employment lawyer, to talk about a very important topic, Employment Standard Act. It's an act that affects our employment process, income. It has reflection almost in all over our life aspects. So thank you so much, Nick, for being here today with us.
Thank you so much, Heather, and it's a pleasure to join you and your listeners. Thank you for the introduction. So a little bit about my background. As Heather explained, I'm an employment lawyer. I practice exclusively in the space of employment and labor law, and sort of been assisting employers in this area for many years, both in South Africa and now locally in Ontario as well. So pleased to join you this morning or today, and to share some thoughts with you, particularly around the Employment Standards Act and what that means. I would say that this is an area of law that's quite busy. It's quite an interesting area of law in the sense that every single person at some point in time is going to have employment of some kind or rely on employment of some kind. So it's important to understand what that legal framework is around employment, your rights, your responsibilities, and more importantly, your entitlements under the legislation. So I thought I'd first sketch out the typical sort of workplace environment where an employee sort of applies for a position, gets employed, and it's at that point in time that there's a crystallizing of rights and obligations between employer and employee. It is possible to be both employed without a contract of employment, or more typically today, we see more and more contracts of employment being used. But regardless of what your particular situation is, whether you have a contract of employment or not, these minimum standards are written into the legislation. So regardless of what your contract of employment says, and regardless of whether you have a contract of employment, there are certain minimum entitlements that the law guarantees to each and every employee, and which the law obliges each and every employer to follow. So I thought that I would share some of the highlights of that legislation. Without sort of making this a legal lesson, we're going to be talking about the Employment Standards Act. That's the minimum standards legislation that applies in Ontario. Each province in Canada has its own legislation, and then federally, if you find yourself working for banks, transportation carriers, telecommunications, internet providers, those are federally regulated organizations, or if you're working for the federal government, obviously, they have a separate piece of legislation known as the Canada Labour Code that regulates their minimum entitlement. So I'm going to focus on Ontario today only, but just to bear that in mind, depending where you find yourselves, there may be a different piece of legislation that applies. So what does the Employment Standards Act generally provide? Well, I've pulled out a couple of highlights that I wanted to share with you, but it effectively is going to regulate hours of work, which is something that's important for each and every employee and employer to know what the expectations are in the workplace around that. So I'm going to discuss the hours of work briefly. It also talks about vacation. As important as it is to be at work and to earn a living, or a salary or a wage, it's also important to have some downtime and try and sort of balance that work-life interaction as much as you possibly can. So vacation entitlements and the minimum vacation entitlements are set out in the legislation. Very important as well, the types of leaves. So sick leaves and so forth. We're going to go through some of the most common ones there. And then what it also does is it regulates what happens at the end of the employment relationship as well. So what happens in the event that you want to move jobs, if you want to resign? What happens if the employer wants to terminate the employment relationship? Can they? And if they do, what are your entitlements at the time of termination, and what are the employer's responsibilities at the time of termination? And then finally, I'll be covering off some of the deductions that can be made from your pay and the appropriate deductions that you're likely to see on a pay stub going forward. So I'll kick off then briefly sort of around the hours of work and those early expectations that no doubt both parties, employer and employee, are going to want to know. And effectively, the Employment Standards Act sets out what ordinary hours of work are, and they obviously set a sort of ceiling to what those are before it becomes overtime hours. So what the Employment Standards Act says is employees can work up to 44 hours in a particular week. And if you're working at 44 hours a week, let's say at $20 an hour, then that would be your ordinary hours of work. What's important, though, is that you may exceed the 44 hours of work. So you may have a situation where you agree with your employer that from time to time, you may work additional hours, or what is otherwise known as overtime. And if you work overtime, that would be those hours that are more than 44 hours in a particular week. It's done on a weekly basis, not on a daily basis, on how we get to overtime. So if you work really late on a Monday, Tuesday, Wednesday, but you're still inside of the 44 hours, you're not necessarily yet entitled to overtime. It's only once you hit that 44-hour threshold for the particular week. Also important to know that if you're working overtime and you're beyond the 44 hours, that your rate of pay also changes. So it's time and a half. So if you're working on $20 an hour, you would effectively be getting 1.5 times that amount per hour that you work as overtime. So keep that in mind when you are concluding employment relationships or when you're going for interviews, or for those of you who are even thinking of starting businesses and you may become the employer. It's important to set out those expectations around working hours and know when overtime arrangements start to kick in, because it does change the rate of pay. And employers will need to comply with that, and employees will be expecting that employers do so. So that was a couple of thoughts around hours of work. As you sort of progress through your career, it's also important to understand that although the Employment Standards Act sets these minimum standards, there are also exceptions to the rule. So the exceptions to the rule on overtime may be that if you're in a managerial position, or if you're in a true supervisory position, you may be excluded from the overtime provisions under the Employment Standards Act. And that's for good measure. If you're the manager, very difficult to keep office hours. If you're a supervisor and you've got a team underneath you, for the same reason, it may be difficult to sort of work sort of more customary office hours, and therefore that overtime provision doesn't necessarily apply. So what does one do if you're working set hours with an employer, but you're working overtime hours, and there isn't necessarily the time and a half being paid on the overtime hours that you're working? So this is sort of an enforcement issue that I wanted to address. Who enforces compliance with the Employment Standards Act? And that's also set out in the legislation. There's an Employment Standards Division to the Ministry of Labour. The Ministry of Labour has contact details which you can find online if ever you need to contact them. You can get hold of inspectors at the Ministry of Labour, and you can either obtain some direction from them in terms of compliance, or they can point you to where the resources may be located. But two, if there's any non-compliance with the legislation, or there's a compliance-related question, the Ministry of Labour would be the natural body to reach out to. It's usually a complaint-based process. So the Ministry of Labour does not tend to conduct spot audits on every single employer or organization. But when they do receive a complaint, that's usually when they kick into action, and they'll start investigating that and determine whether there's compliance with the legislation or not. Once the Ministry of Labour goes through its investigation and renders a decision, the employer and employee generally are required to comply with that, or either party can then challenge that decision further by going to the Ontario Labour Relations Board. So there is one further step beyond that in terms of the legal process that follows. But coming back down to sort of just general compliance, it all resides with the Ministry of Labour and the Employment Standards Division thereof. There have also been some recent cases in Ontario, I would say, where disputes have arisen around hours of work, overtime pay, bonuses and commissions, vacation pay, which I'm going to touch on in a few moments. And the question there is, I didn't realize that I have the right to be paid overtime, or I didn't realize that I have the right to be paid vacation pay on my commissions or my bonus until I maybe listened to one of these sessions or heard about it online. And the question may be, how far back in time can you go to claw back the monies that you were short paid? And that answer has been given affirmatively now, both in legislation and in case law. And effectively, you can go back at least 2 years. In some cases, in the case of vacation, you can go back a little bit longer, and I'll share the reasons why. But 2 years is generally the cap on any employment-related claims. You wouldn't be able to claim beyond that. So something to keep in mind, sort of as you're moving through your relevant careers. I thought it would also be important to just stick with hours of work for a moment here and just talk about lunch breaks or meal intervals, and what the expectations are around those. Again, this minimum standards legislation in the form of the Employment Standards Act, I may refer to it as the ESA, sets out what the expectations are from the legislature standpoint. And effectively, what is required is that for every 5 consecutive hours of work, you are entitled as an employee, and your employer is obliged to give this to you, a 30-minute meal interval. So 5 consecutive hours of work, 30-minute meal interval. That's typically your lunch break, and typically that lunch break would be unpaid. And I wanted to make a quick point here. As we're talking about minimum standards, it's obviously possible for your employer to exceed those minimums. So if an employer wanted to give a longer lunch period, if an employer didn't require you to work the full 44 hours a week, if there's more beneficial terms and conditions in the employment relationship, those are obviously all appropriate, provided they do not fall below the statutory floor that is set by the Employment Standards Act. So that kind of takes care of lunch breaks. I do sometimes get the question, well, what about coffee breaks outside of those? So maybe a morning coffee break and an afternoon coffee break. Those are not in the legislation. If your employer decides to give those to you, they're giving them to their employees sort of freely and voluntarily, but no legal requirement around those. The only legal requirement is the every 5 consecutive hours, the 30-minute break. So it's all fine and well. You're working your hours, you're getting paid. What about time off? You know, you've been working hard. You want to spend some time perhaps with the family or do some traveling. What does the Employment Standards Act say about vacation entitlements? And again, I'm going to break it down very simply. It can get more complex. But what the Employment Standards Act basically suggests is, or not suggests, it prescribes that for an employee with up to 5 years of employment tenure, you're entitled to 2 weeks of vacation. And for employees with 5 years or longer, you're entitled to 3 weeks of vacation per year. Now, let that just sink in a little. There are circumstances where employers will perhaps give more vacation than what the Employment Standards Act provides. But again, these are the minimums. So under no circumstances, if you're a full-time employee, should you be getting less than 2 weeks of vacation per year. And I stress the fact that you would have to be a full-time employee. There are other requirements for part-time employees where it's calculated on a smaller scale, obviously. In terms of your vacation entitlements, the Employment Standards Act also sets out the expectations as to when you should use those vacation entitlements. And it basically provides that if, let's say you're a 3-year employee, so you're inside of the 5-year period, you would be entitled to 2 weeks of vacation per year. The Employment Standards Act says that you can use those 2 weeks within that year and by no later than 10 months in the year that follows. So there is a cutoff when you should be using your vacation. So just important to understand that. And then typically, when you take vacation, you're not going to be working. So ordinarily, you would not be paid because you're not at work. But again, the Employment Standards Act comes in to regulate that, to ensure that employees are not out of pocket when they do take vacation. And it provides that for those employees who are entitled to the 2 weeks of vacation per year, you should be getting 4% vacation pay on all of your wages per year. That money is set aside or it's paid to you with every paycheck. There can be differences and nuances from employer to employer, but that money is being paid to you in order to cover off the pay for the time that you're off on vacation. And importantly, it's on all wages. So it's on your income, it's on your commissions, it's on your bonus payments. The 4% needs to be paid on all of that. For employees who have more than 5 years of tenure or work service with a particular employer, you're entitled to 3 weeks of vacation per year and 6% vacation pay. Again, the company can either accrue that or your employer can accrue that for you and pay it out at the time that you take the vacation, or alternatively, they can pay it to you on every paycheck, provided there's an agreement to that effect. So that's kind of how vacation works. It's a little bit nuanced, I would say, in Ontario, in the sense that you've got vacation time, which accrues, and then you've got vacation pay, and the two are sort of seen as distinct. They do work in harmony together, but they are regulated and accrue under different provisions under the legislation. Importantly, what happens to your vacation time when you're terminated? If you have accrued vacation, that's obviously paid out at the time of termination, so you shouldn't lose it. There's also case law to suggest that vacation is held in trust by the employer. Vacation pay, at least, is held in trust by the employer. So those entitlements don't go away, provided you are using them in accordance with the legislation. I thought we'd then move along to the types of leave. There's only a few that I wanted to discuss. The first is sick leave. Unfortunately, we all get sick from time to time, and you may require time off to recover, go and see a medical practitioner. The legislation provides each employee with a minimum of 3 days of sick time per year. It's not something that accrues. It's not something that you get to take no matter what. It's specifically kept aside for sick leave type circumstances. And the reasons would be personal injury, illness, or medical emergencies would sort of be covered underneath there. When it comes to sick leave, I think that there are some responsibilities on the employee as well. Obviously, you're responsible to try and, as far as possible, inform the employer prior to taking sick leave that you're going to need to do so. And an employer may require a medical note from you, provided it's reasonable in the circumstances. So you may need to get a doctor's note in order to support the fact that you're off on a sick leave. Those 3 days that I spoke about are unpaid. So the employee does not get paid by the employer for the 3 days that they are off. When it comes to sick leave, provided where, and particularly where it's prolonged, employees would apply to the Employment Insurance Office. That is a deduction that you'll see come off your salary each and every month, and you'd claim EI for the time that you're off on a sick leave. And you'd submit a claim through that government office. Pregnancy and parental leave, something else that comes up quite frequently, I would say. With regards to pregnancy leave, again, it's unpaid by the employer. Some employers may decide to pay, some employers may decide to top up salary and certainly would continue benefits over the period. But these are the minimums that you're entitled to. So 17 weeks, it's just over 4 months, which is pregnancy leave. And then over and above that, there's a parental leave, which can be taken by the pregnant spouse. And that's a total of 61 weeks. So you put those two periods together. And then if pregnancy leave is not taken, then there's a total entitlement of 63 weeks. And what we often find is the parental leave component, which is that longer period that I explained. Generally, that can also be shared between spouses as well. So I think that's important to share. We've also seen some interesting developments in the years where same-sex partners, not necessarily the or even adoptive parents, taking parental leave. So the law is definitely moving in a new direction and keeping up with modern times, which is good to see. Some other leaves, we've got family responsibility leave, family caregiver leave, and family medical leave. There can be critical illness leave. All of these are regulated under the Employment Standards Act. And then maybe the more unfortunate one, bereavement leave, if there's been a passing of an immediate family member. That's 2 days unpaid leave that you're entitled to under the legislation. And bereavement leave, you would qualify for that leave if it's a spouse, parent, child, sibling, or a dependent relative. So that's what the legislation sort of provides. And then I thought we would talk about terminations. This is such a big topic on its own, as is the Employment Standards Act, but I know that we've got limited time, and really my idea here today is to share just those minimum thoughts with you of the most pressing issues that you're likely to come across and create some awareness. But when it comes to terminations, I'm going to speak about the Employment Standards Act alone. It's important that you know that the common law, which is a separate legal system that sort of operates alongside the statutory system, the common law may apply here as well. So there may be additional entitlements that employees are entitled to, but I'm focusing just on the Employment Standards Act for purposes of today. So if there is a termination, let's first talk about you wanting to move from one job to another. Generally, resignations are provided for in the contract of employment, and generally it's a 2-week notice period. Your employer may decide to release you earlier, but would still then be required to pay you out the balance of the 2-week notice period. That's if you want to resign and you want to end the employment relationship. What's the position if the employer wants to end the employment relationship? Well, despite talking about all the reasons that they may want to do that and the nuances related to those, I thought it would be important to concentrate on the employee's entitlements, the minimum entitlements at the time of termination. So interestingly, under the Employment Standards Act, between 0 and 3 months, there is no entitlement to notice, at least under the Employment Standards Act. So if you've started a new job recently, and unless your contract provides to the contrary, if you are terminated inside of the first 3 months, you may not be entitled to any notice whatsoever, not under the Employment Standards Act. Once you get beyond the 3-month mark, but you're inside of 1 year of employment, so still a short-serving employee, you're entitled to 1 week's notice of termination. Then that 1 week can either be paid to you as a lump sum payment, or it could be paid to you by way of salary continuance, or you can be given working notice, where the employer says, we're terminating your employment through the provision of working notice. You will still work for 1 more week, but we're telling you today 1 week in advance that at the end of next week, your employment is at an end. So provided they observe in some way that notice entitlement, they would likely be compliant with the Employment Standards Act. It operates then on a sliding scale. So once you get beyond 1 year of employment, up to 3 years of employment, you're entitled to 2 weeks of notice. And then it operates on a sliding scale, 1 week per year, up to a maximum of 8. So if you're an 8-year employee or longer, it caps, there's a maximum notice entitlement of 8 weeks. So that would be your payout or your working notice period or your salary continuance period at the time of termination. But that's not all that employees are entitled to, and that's not all that employers are obliged to provide at the time of termination under the Employment Standards Act. If we are talking about, let's say, a 4-year employee who's entitled to 4 weeks notice under the ESA, they would get their 4 weeks. They would get benefit continuation, provided you receive benefits under your employment contract for that same 4-week period. And you would also get vacation accrual for that same 4-week period. And then there's one additional component that potentially applies outside of the common law and under the Employment Standards Act. And that's if you have been employed for a period of 5 years or more, and in addition, your employer meets the payroll threshold annually of 2.5 million per annum. In those circumstances, there's additional notice that's required, which is called statutory severance. It's a prorated severance that's paid to the employee over and above their notice, and that's 1 week per year of service, up to a maximum of 26 weeks. So it's quite a large payout that can happen. If you're a very long-serving employee, you could be getting the maximum of 8 weeks notice of termination, plus the 26 weeks of statutory severance, provided you meet both criteria. And then I thought we would finish, just to make sure that we respect everyone's time and keep within the time allocation, just some of the deductions that you're likely to see on your pay stub. So there will be deductions for income tax that you will see on the pay stub. There'll be a deduction for CPP, which is Canada Pension Plan, those contributions being paid over to the government, and then employment insurance deductions that are paid over as well. And those are in the instance that you need to claim EI for some of the leaves that I spoke about earlier. Those are the statutory deductions. Those are the authorized deductions that you'll see on your pay stub. The only others that you should be seeing are those that you've agreed to in writing with the employer and where there's a clear method around calculating those deductions. Otherwise, you should be getting your salary less those 3 and nothing more than that. So that kind of in a very brief nutshell, in the short time that we've had, encapsulates some of the main components of the Employment Standards Act. And hopefully if there's any questions, you can send those back, and I'll try and reach out to Heather and provide answers to those. But this is a general proposition and overview of the Employment Standards Act. So thank you for joining us, and yeah, best of luck for each of you in your careers. Thank you.
Thank you so much, Nick. If you don't mind, I do have some questions.
Absolutely.
Well, thank you, sir. You've mentioned something about common law. Can you elaborate a little bit about the concept? What do we mean by common law?
Sure. So there's two legal systems. There's the system where sort of historically, as the law was developing, and I'm going back hundreds of years now, but as the law was developing, we didn't necessarily have things like legislation and statutes. So what would happen is the king or the queen would hear disputes and make decisions. And from there, kings and queens started to appoint judges and decision makers. And so we had this development of a legal system over time. And those decisions that were then rendered by those decision makers became the common law. So it sort of acted as a precedent or some indication of what we do in similar disputes, what the courts or decision makers have decided previously. And so that gives us some direction on what would be followed or what the position is in law today. That process has continued over hundreds and thousands of years. And so, or maybe hundreds, not thousands, but that process continued over hundreds of years. And we still have that today. So where a judge makes a decision based on a particular case today, let's say it's a 35-year-old female employee who's an engineer who gets terminated after being employed for 8 years, the judge may say that that employee is entitled to certain payouts at the time of termination. That case is common law. That case can be used in other similar cases where there's maybe another 35-year-old engineer with similar sort of periods of employment, and you can use those in order to influence the next decision maker to follow that precedent. I would say that where it comes to terminations and in the employment space, the common law is frequently used. It doesn't always apply. It can be excluded through the contract of employment, but if it is not, or if your contract of employment is unenforceable for whatever reason, judges will look at this precedent. They'll look at the common law. They'll have a look at as many other decisions as are possible with similar facts, similar circumstances, in order to assist that decision maker and that judge to make a similar decision, so that we have some sort of parity, some sort of consistency in the law. And it also helps lawyers sort of advise clients, I would say, in terms of what the framework of expectations are and what the likelihood of success is at trial, if it ever gets to a hearing. So the common law is basically a separate legal system that applies alongside the statutory system where we have legislation. The two sort of overlap, particularly in the employment space, and they may both apply in certain circumstances as well.
So much, Nick. Talking about termination of employment, I know that there's something called dismissal with cause and dismissal without cause. So can you elaborate a little bit about the concept of those?
Sure. And I would say to you, that's a fantastic question, Heather. It's a question that we could probably spend a morning on, because there's so much development in the law on this. But I will basically sketch out the three main terminations that we have in Ontario, at least. So we've got the regulations to the Employment Standards Act. It's regulation, I think, 288.01, if anyone wants to look it up, which basically says if you're terminated for willful misconduct, willful neglect of duty that's not condoned by the employer, or disobedience, any of those very serious and significant offenses, provided the employer can obviously prove those. But if those are the grounds for termination, it's a summary termination. There is no notice, there's no statutory severance. You get terminated on the spot and you only get paid your entitlements up to the date of termination. That's the most serious. Let's call that item number A. If we come down the ladder to item number B, we have terminations for cause, which is the common law standard. It's again judged to a high level or a high degree. It is still conduct that irreparably breaks down the relationship of trust between employer and employee, and is still grounds for termination. But on a for-cause termination, and this is only in Ontario, you would still be entitled to your ESA minimums. So your notice of termination, statutory severance if it's applicable, benefit continuation for the ESA period, and accrued vacation. So you would still get those in the event of a termination for cause. And then you get to sort of the lowest level, which is, let's call it item number C on the ladder, which is a without cause termination. That's where the employer is saying to an employee, I don't necessarily rely on any misconduct or any inappropriate behavior for my decision to terminate you. It may be some other unrelated reason, such as it's just not a good fit. Maybe the company's not doing very well. maybe they're needing to downsize, they would then implement a termination without cause. And in those circumstances, the employee would get paid out at the very least their ESA entitlements. And potentially, depending on their contract of employment, there may be additional entitlements under the common law, which is what I just sort of explained. And again, it's a bit of a convoluted topic, but there may be additional payments more than just the ESA on a without cause termination. But really, you would have to speak to a lawyer to determine whether you have those entitlements based on your contract of employment. The one benefit I would say to you with a without cause termination is that you would still be able to claim EI benefits because you haven't lost your job for any reason that you're responsible for. So you would usually get a record of employment at the time of termination. It may be coded under Code K, which is the other provision, and the employer would put a notation there to say terminated without cause. That would entitle that employee to still claim EI benefits while they look for alternative employment. So 3 main reasons why an employer or how an employer may terminate in Ontario. And they get a little bit more technical. So I would say to you, if anyone finds themselves in one of those 3 scenarios and you're wanting some more information, it's probably a good idea to go and speak to someone who's trained in the law or legal representative or counsel and just take some more advice, because we are seeing new decisions in the termination space sort of every month or 2. And there's a lot of development in this area, which makes this an exciting area for me to practice in, certainly, but maybe a little bit more complex to traverse as individuals who are not skilled in the law. So yeah, just word of caution there. Maybe take some advice if you find yourself in that space.
Thank you so much, Nick. And last but not least, could you please elaborate about the term you've just mentioned, EI? What do you mean by EI? What is it? What's the eligibility requirements? Just in a short.
Sure. Yeah. Thank you, Heather. So EI's employment insurance, as I mentioned, it's one of the deductions you'll see on your pay stub each pay period. It's paid over to the government, and you would effectively be applying through the government office at the time that you lost your job, or you've got an interruption to earnings. So for instance, let's say you have to commence with a medical leave, which is prolonged, and you need to claim EI. You would make an application through the Employment Insurance Office. You'd fill in their forms. I believe you can do it online now and all electronically. And what they would effectively be doing is, based on your contributions that you've been making and those deductions that have come off your salary, they will pay up to a maximum of 55% of your weekly earnings to you. There are certain criteria and qualifiers. It's based on insurable earnings. So if you've had very short employment, you may not qualify for all of it or for a very long period of time. But it's a social assistance scheme set up by the government to basically support employees who find themselves in situations beyond their control where there's an interruption in earnings, and to ensure that people aren't sort of left destitute during those tough times, that there's some income at least coming in to cover off expenses.
Thank you so much, Nick. And I do believe that employment process is interacted with other legislations such as human rights, which would be subject to our next session. So if you can just yeah, this is something that we are going to address in our next session. But is it also interacted with other types of law, such as, for example, tort law or contract law?
Absolutely. I would say in the employment space, there are so many areas of law that apply. So we've got the Employment Standards Act, as I mentioned. We've got the common law, which we very briefly touched on. If you're federally regulated, if you're working for a federal employer like banks, transportation, telecommunications, we've got the Canada Labour Code. We've got the Human Rights Code in Ontario, which applies, and the Human Rights Tribunal of Ontario, obviously. There's the Occupational Health and Safety Act. There's the Workplace Safety and Insurance Act and the board and tribunal that follows there. We've got the Labour Relations Act, which applies in unionized context. We've got pay equity. So there's, and a lot of these pieces of legislation also have regulations too, and are amended frequently, I would say. So the law is always evolving. And then on top of that, we've got judges who are grappling with issues that fall under this legislation and then rendering decisions which add to the common law that applies. So sort of a myriad of areas that need to be considered when there's an employment dispute. And I would say, Heather, as you know all too well, when these disputes arise, often there's more than one piece of legislation or more than one law that's applicable, just depending on the set of facts. So it can become confusing, but hopefully we've given a brief overview of just what some of the main minimum standards are and entitlements under the legislation. But yeah, important to bear in mind that your questions, concerns, or experiences may reside under a different piece of legislation, depending on what's gone on. And all of them are sort of as important and possibly even as complex as the other. They're all topics in their own.
Thank you so much, Nick, for this informative presentation. I think we covered the main aspects in brief about the Employment Standard Act, and as you've just said that if there's any other questions, people can just post their comments on the chat, and they might be subject for another sessions. So at the end of this, I would like to thank you, Nick Preston, for your valuable time and valuable information. Thank you for joining us today.
Thank you.
And for